The Supreme Court has issued a landmark decision on whether or not the federal government is allowed to coerce social media platforms in directly censoring your free speech. This is a significant case that impacts everyone watching this video, and everyone nationwide. This impacts your First Amendment rights online. So let's talk about what is happening. Now, really quick before we jump into this video, I want to thank the sponsor of this video, which is TacPack. TacPack is a subscription-based box that delivers tactical and EDC gear to your front door every single month on a subscription basis. TacPack offers two different tiers. They have the standard $59 tier and then the Plus box, which is $139. My personal favorite is the Plus box because you get a ton of value in that box, even more than what you're paying. And right now, TacPack is actually doing something very special for my viewers. If you use the code ARMED and it's your first time ordering, you will receive a free $60 tactical gear box along with your order. So I will leave a link down below to TacPacks. Make sure you actually use that code ARMED if it's your first time. Get that free additional tactical gear box. I highly recommend it as a Christmas gift for, the guys out there, or if you want to get it for yourself, it's a great Christmas gift. So again, use that link down below and use my code. As I mentioned in the intro, in this video, we're going to be discussing a very important decision recently issued by the Supreme Court. And this decision directly impacts your First Amendment rights and your right to free speech online. The Supreme Court recently issued a 6-3 decision in a case called Murphy versus Missouri. In the decision, the Supreme Court believed that the plaintiffs there lacked standing to bring this lawsuit against the federal government, since the Supreme Court believed that there was not a clear enough link between the federal government and the social media companies which were engaging in censorship. What this means in practical sense for you and me is that the Supreme Court found that the federal government could not be blocked from coercing or pressuring social media platforms who are engaging in censorship of our free speech. But this battle is far from over, and the case is currently proceeding forward at the lower court level despite what the Supreme Court just said. So let's talk about what happened in these cases, what the Supreme Court said, and where these cases go from here. Now, in this case, Missouri and Louisiana, along with 5 individual social media users, sued executive branch officials and agencies, alleging that the government pressured the platforms here in question to censor their free speech in violation of the First Amendment. Now, in this case, the plaintiffs asked for the district court to place a preliminary injunction against the federal government and various agencies who were engaging in this conduct. Now, after extensive discovery, the district court here issued a preliminary injunction in favor of those plaintiffs. The court here held that the White House officials and then other agencies and other officials likely engaged in coercion and significantly encouraged the platforms here in question to engage in censorship. So the decision here blocked the federal government from pressuring social media agencies, social media companies, or employees, or whoever from censoring our free speech here online. Of course, the federal government did not like that. They did not like that decision, so they appealed up to the Fifth Circuit. And on review, a 3-judge panel in the Fifth Circuit actually agreed with the lower court. They agreed with what the district court said, and they concluded that the officials' communications rendered them responsible for the private platform's moderation and those decisions. The Fifth Circuit then affirmed a sweeping preliminary injunction against the federal government. The federal government then didn't like that, so they sought a rehearing en banc in the Fifth Circuit because they had lost twice now, so they wanted the Fifth Circuit en banc panel to reverse those decisions. That was granted by the Fifth Circuit, but once again, the Fifth Circuit sided with the plaintiffs. They sided against the federal government, and they ruled that they needed to protect our First Amendment rights online. The Fifth Circuit en banc panel first held that the individual plaintiffs had Article III standing to seek injunctive relief, and they reasoned that the social media companies had suppressed the plaintiff's speech in the past and were likely to also do so going forward in the future. They also found that all these injuries were traceable to the government coerced enforcement of the platform policies and that they were redressable, that the injunction could actually cure these issues. The court also concluded that these states had standing both because the plaintiffs had restricted the posts of individual state officials and because the state has a right to listen to their citizens who are on social media accounts and that are online. Applying this analysis, the Fifth Circuit determined that the White House officials, in conjunction with other agencies, other individuals in the federal government, had encouraged the platforms to moderate content, and they also found that there were other agencies like the FBI that had done the same, and based on that, they agreed with the district court and they upheld the sweeping preliminary injunction which blocked these activities. But the Fifth Circuit en banc panel actually went a little bit further. The Fifth Circuit issued a modified decision which was even more expansive. The court did not limit the injunction to just the platforms in question, and also not just the plaintiffs in question. They applied it to all social media accounts, all online activity, and all individuals. So it was much more expansive, so the en banc panel agreed with us even more and wanted to stop this conduct. Now, again, as a result of that decision, the Biden administration then sought emergency Supreme Court intervention. They went to the Supreme Court asking for the Supreme Court to step in early and to stop these decisions. The Supreme Court granted the emergency application and then granted a full review to this case. And like I said, on review, the Supreme Court entered a 6-3 decision siding with the federal government. The 3 dissenting justices were Alito, Gorsuch, and Thomas. So Alito, Gorsuch, and Thomas wanted to side with our First Amendment rights, but they were outvoted. Now, this majority opinion was written by Justice Barrett, and Justice Barrett, writing for the majority, stated that the Fifth Circuit was wrong to grant the sweeping preliminary injunction because the court believed that the plaintiffs lacked standing to bring this lawsuit against the federal government. She stated in the opinion that the Fifth Circuit was wrong to do so. To establish standing, the plaintiffs must demonstrate a substantial risk that in the near future, they will suffer an injury that is traceable to a government defendant and redressable by the injunction they seek. Because no plaintiff has carried that burden, none has standing to seek a preliminary injunction. She went on to state that the plaintiffs fail by and large to link their past social media restrictions and the defendant's communications with those platforms. In the majority's opinion, there was not enough evidence to link the censorship that happened with the communications between the federal government and then those social media companies. The Supreme Court also believed that the injury could not be redressed, aka cured by the court here or by any court, because there was no evidence of any future or continued harms that would happen to those plaintiffs. And based on that, they reversed the decision of the Fifth Circuit en banc panel and sent the case back down to the lower courts for a new decision. Now, like I mentioned, Justice Alito wrote a dissent which was joined by Thomas and Gorsuch, and in the dissent, he stated that this case should be one of the most important free speech cases to reach the Supreme Court in years. He stated that this case involves what the district court termed a far-reaching and widespread censorship campaign conducted by high-ranking federal officials against Americans who expressed certain disfavored views. He concluded his dissent by stating that for months, high-ranking government officials placed unrelenting pressure on social media providers to suppress Americans' free speech. Because the court unjustifiably refuses to address this serious threat to the First Amendment, I respectfully dissent. So that was the 6-3 decision that was issued by the Supreme Court, which ultimately protected the attacks against the First Amendment and our right to engage in free speech online. Now, after this ruling, the case was then sent back down to the Fifth Circuit and then ultimately sent back down to the District Court for an evaluation based on what the Supreme Court said. Now, interestingly, the District Court judge here, Terry Doughty, is actually allowing this case to move forward despite the fact that the Supreme Court found that there was no standing when it came to the preliminary injunction. The District Court judge here found that legally there is a heightened standard to show standing when there is a review of a preliminary injunction, but general standing for a lawsuit to proceed forward is a lower bar, and based on that, he believes that there is a general lower bar standard of standing here for this case to move forward against these social media companies and then also the federal government. Therefore, the Supreme Court ruling does not mean that the entire case will be thrown out. This case is moving forward. There's currently additional discovery that has been ordered to also further establish standing to see if this case will move forward towards a final merits decision. So this is a very important case that we should be watching very closely going forward. You had a Supreme Court decision that in some ways seemed like it was going to end this case, but this case is still moving forward. The District Court judge, it clearly shows interest in wanting to allow this case to move forward. He ruled in our favor before. He ruled in favor of protecting the First Amendment, and it seems like he is trying to keep this case moving forward. So if anything else develops, I will let you guys know. So if you guys like this video and you'd like to support the channel, really one of the best ways to support the channel is simply liking, commenting the video, and subscribing. And really one of the best ways to fight back against censorship online that we all face is simply getting these videos and sharing them to at least one other person that you know who maybe would be interested in these topics. So again, thank you guys so much for all of your support. But as always, thank you all for watching. Don't forget to like and subscribe. And never forget, this nation was built by armed scholars, and this nation will be maintained by armed scholars.